Today, I'd like to go over successor and interest issues. Uh, that's the beautiful legal term. This is generally when somebody new becomes the owner of the property. Uh, there's a lot of issues when it comes to this. It's very state specific. Uh, can you give I'm gonna plug the NCLC here again. NCLC has done incredible work on this. I won't drop any names, but there's some incredible people that have absolutely torn this topic apart and lay it out in such a beautiful, succinct way that it is understandable. Um, we're more in the problems that we have seen category. You want to the academic, go look over there, but the typical problems that we've seen or you see in your practice, I don't know, the last two or three of these cases that you've had, what have you seen, or
I
what,
can
just
give
describe.
you
Go ahead.
I can give you an example of one that I just went through, and it's typical of what happens.
Okay.
Mom, mom passes away. Mom leaves property to son. Son is also the executor of the estate. And I know I'm using lots of legal terms here, but he's in charge of administering it too. So he's the heir and he's in charge of administering it. He contacts the servicer and says, "Hey, mom's passed away. Um, I'm I'm the I'm administering her estate. I need to let you know that." And because the will gives him the property, family thinks that gives him the property, and he doesn't understand all the extra steps that have to go, through the court process to actually get the title to the property. He gets in contact with the servicer. The servicer will have communication with him as the representative of the estate. And so people get really confused about, even though you're a successor in interest as defined, remember, if you show that you have your potential successor, so the servicer uses those words, a potential successor in interest, and then the final step is a confirmed successor. So you can be a potential, but that doesn't mean you have the rights of a true successor in interest until you're confirmed. And so there's all these steps that have to go in between. And a lot of borrowers get so confused and they will end up in foreclosure because of the language. Nobody's speaking the same language. And certainly the service representatives that they're talking to at the service, they don't know. They just know what's on that screen. And it's maddening to clients. So like, I sent mom's will, I sent the death certificate, I gave them what they asked for, and they won't talk to me or they won't give me any options. And then the home ends up in a foreclosure. And now we're trying to unwind it simply because there was poor communication and they didn't really understand exactly what they needed to do. And I see that happen all the time. And it's very frustrating because all you needed to do is step A, B, and C and would have been confirmed.
Absolutely. And instead, they go around that vicious cycle of he said, she said, they told me. They don't document anything, and then they end up in foreclosure. Then, especially in a state like Alabama, you could end up losing your home because you did not get some competent help. And it's sad, but I'll repeat it again. With these issues, this is your house. This is most people, it's all they have, or it's a very large part of what they do have. Uh, get help, find somebody local, find an attorney that can walk you through these steps. Don't rely on the he said, she said of what the bank said. It's not advisable. Not advisable. Get help.
Right. And it's not really even that the banks, they may be trying to help you, but they don't half the time know what they're talking about. So it's like
Correct.
you've got to give them the information and the borrower the information to get everybody on the right path a lot of times.
And in my world, I feel like I'm teaching them. I explain it to them. I tell them how it works versus asking them how it works.
Right.
Because to get to that next level, a person that can actually read what the guidelines say.
That's fun.
Okay. Thank you once again, Rhonda.
So